On behalf of Jones Day, we would like to welcome you to GDPR in Detail, Analysis of DPA Guidance and National Implementation Efforts. This program is scheduled to run from noon to 1 p.m. Eastern Time. If you are having difficulty hearing me, please check to make sure that you have the volume on your computer turned up all the way. If you have any other technical difficulties, please contact the Beacon Live Help Desk at 1-877-297-2901. Also, if you have not already downloaded a copy of the CLE Credit Information Sheet, you may do so from the Handouts tab on the left. A copy of the presentation materials will be emailed to you after the webinar. This presentation has been approved for CLE credit for attendees. The CLE Credit Information Sheet provides you with information regarding the available credit. Applications for CLE credit in other states will be made as needed. Please keep in mind that CLE credit is not available when viewing the on-demand version of this webinar. There are several important steps that you must take to demonstrate that you are actively participating. First, each participant must have registered individually for the webinar in order for your time of attendance to be recorded. If you have not individually registered for this webinar, please do so immediately by contacting Wendy Sung at wendysung@jonesday.com. Second, at various points during the webinar, a box will pop up on your screen asking you to confirm that you are viewing the webinar. You have up to a minute to confirm participation. If you do not confirm each time the box appears, you will be denied CLE credit. Third, you must be logged on for the entire presentation or segment. Otherwise, CLE credit will be denied for that segment. Within 24 hours, you will receive a link to generate your CLE certificate. If you do not receive the email, please contact the Beacon Live Help Desk or email cesupport@beaconlive.com. It is mandatory to enter your bar number. If you cannot locate your bar numbers, please contact the Beacon Live Help Desk for assistance. You will be in a listen-only mode throughout the presentation. If at any time you have a question, you may submit them through the chat window located in the lower left corner of your screen. We will attempt to answer those questions at the end of the webinar. With the housekeeping out of the way, I will now turn it over to the live presentation.
Thank you very much, and welcome to all attendees to this third session of our webinars on the implementation of the General Data Protection Regulation. For those of you who have been able to attend, the first session was addressing the top 10 implementation issues with the GDPR, and the second was focusing on how to develop an effective GDPR compliance program. But as you know, the devil is in the details, so we would like to focus in this third session on the DPA guidance and local implementation efforts that are on the way to prepare the GDPR that will be effective on 25 May 2018. So to address this topic, I have with me instrumental colleagues within our EU practice, and this is Paloma Bru from our Madrid office, Laurent de Muiter and Jörg Hadig from Brussels, Giuseppe Mezzapesa from Milan, Liz Robertson from London, and Undine von Diemar from our Munich office. Our agenda today will first start with the guidance that has been issued by the Article 29 Working Party on the Data Protection Officer, the portability, or the right to portability, and the lead authority and the guidance that's been issued for the identification of the lead supervisory authority. And then we'll jump in for the local specifics on implementation efforts and guidance from the different DPAs for the key member states, some of the key member states of the European Union. And finally, we'll wrap up with a Q&A session. With this, I'll open the floor to York for the guidance on DPO.
Yeah, thanks very much, Olivier. And so the first topic is the recent guidance issued by the R29 Working Party on data protection officers. I should be more precise on the designation of a data protection officer under the new framework in Europe, the General Data Protection Regulation. So obviously, the authorities recognize that data protection officers, not only today but also in the future, will play a key role in the new framework and will facilitate compliance with the provisions of the regulation. There's actually three different categories that I would like to present to you that we found in these guidelines by the authorities on how a DPO has to be designated. The first category I will talk about is mandatory designation. So the regulation basically requires the designation of a DPO in three specific cases. The first one, you see that on the slide, is when your core activities of the company have to do somehow with the regular and systematic monitoring of individuals on a large scale. I'll explain in a minute what this is. The second scenario where you have to do that is when the core activities, again, have to do with the processing of sensitive data and similar data on a large scale. Now, what is it when we're talking about core activities? Basically, this is has to do with your main business as an organization. So if you have a company and you're, for example, in a manufacturing business and you have to process employee data, that does not mean that the employee data processing that you need to do by nature of running an organization is a core activity. That's more like an annex to the actual processing activities. And then large scale, just to explain that a little bit, is the examples in the guidelines you can find for a hospital, for example, insurance company. If they process sensitive data for obvious reasons, then this is meant by large scale for these type of organizations. The assessment is very easy to designate a data protection officer. And then last but not least, when national law, member state law requires it, for example, in Germany, we'll hear about that later, then also when a member state retains the system of having a DPO, you are required, at least for that country, to make that determination. There's also the option, the guidelines will recognize this, to have voluntary DPOs designated, highly encouraged by DPAs, where you feel you don't fall in the three categories of mandatory designation, but it may be useful and helpful to have a person that's in charge in the organization to handle data protection issues. I'm moving on to the last category, that you can also designate, appoint people in the organization that are in charge of data protection, but you don't have to call them necessarily data protection officers. So you can call them data protection coordinators, for example. Other terms are usually used in practice as well. And these type of people would not have to follow the quite strict requirements in terms of the GDPR and the guidelines. Usually, every DPO must be designated based on the level of expertise, professional qualities, expert knowledge on the law. That's very detailed, set out not only in the regulation but also in the guidelines, so that the person can fully handle its position. It's a given that that person has to be involved early, according to the guidelines, in any kind of projects that involve data processing, and that person must have the appropriate support and resources to carry out its tasks, has to go on to training, to maintain expert knowledge, and to have access, of course, to data processing operations. On my last slide for today, you will see the important element that's emphasized also by the guidelines and of the authorities. The DPO should act in terms of exercising at least the role of being a DPO in a very independent manner, should be very free from instructions of management of the organization, and is also protected at the same time, according to the guidelines, against dismissal or penalization of performing its tasks. There's a reporting line as well, DPOs must directly report to highest level of management of the company in order to have that level of independency is very important. Companies struggle a lot how to implement this with an existing governance structure, so that's something that requires a lot of strategic discussion in the organization. And then there's also a long list in the regulation, and the guidelines provide a bit more detail here on what the DPO has actually to do in practice, right? It's important what is actually the job of that person that you have designated. And you can see this here on the slide. The person has to inform, advise the companies on data processing obligations, monitor compliance and policy specifically, train staff, often overlooked. Now it's vital in order to flow down the culture of data protection and the framework and make people aware by training. There are instances where the DPO can give guidelines in terms of data protection impact assessments. And last but not least, the DPO is the main contact point for any issues that have to do with dealing with the authorities, and act as a contact point and relationship management. And with that, I hand over for the next topic to my colleague Giuseppe. Thank you.
Many thanks, Jörg. Let's go to see in some more detail the second of the three sets of guidelines which have been issued by the Working Party. This actually refers to portability. What are we referring to? Well, I mean, portability is a new right which has been set forth by Article 20 of the General Data Protection Regulation. And it's something actually new because it is related to the right of access, but now has a different and specific purpose because it aims to facilitate the right of data subjects to move from one IT environment to another without actually having hindrance. So the point is to obtain the possibility of switching from maybe one operator to another one, and this is something that has happened quite often in our recent life when we are dealing with buying a new smartphone and we want to move the data from the old device to the new one. Essentially, the right to portability consists in the right to receive personal data and to store them on our private device. And this even without the need of transmitting the data to another controller. The guidelines issued by the Working Party expressly regulate the allocation of responsibility because also they clarify that the data controller transferring the data shall not be responsible for the subsequent processing which is being carried out by the data subject or by another controller, which is the one receiving the data. The guidelines also give clarifications about the timing for replying to the request of portability issued by the data subject. The reply shall be given without delay and in any case within 1 month unless there are specific complex cases for which the reply could be provided in 3 months. But just bear in mind that this longer period in practice should not be applicable because controllers will have to implement means allowing to reply to the request of data subjects in a quick way. Let's go also to clarify whether fees can be charged by data controllers for replying to those type of requests. The answer is no. Fees cannot be charged by data controllers unless there are cases of unfounded and repetitive requests. In any case, the guidance provided by the Working Party also clarifies that these cases should be negligible and actually limited to very, very few hypotheses. Let's check the conditions under which the right to data portability can actually exercise. Well, the personal data must concern the data subject, of course, and the processing shall be carried out with automated means. This implies that if we are referring to data stored for some reason in paper archives, this is a right that data subject cannot be exercised against their data controller. The data shall also be data provided by the data subject, even knowingly or by virtue of using the device. So either by completing a form or even by simply using the device. So in principle, the device may have a form of memory which indicates the first 5 numbers which are called more often. And this is a type of data which is provided unknowingly by the data subject. Last condition is that portability shall not affect adversely the rights and freedoms of other individuals. And this is typically in the case in which IP rights should be involved in the portability, or maybe for banking transactions where also data of a third party may be mentioned. So this is another condition. And so these are the basics of the guidance provided. I just want to add that in practice this means, first of all, that will have to be implemented means for replying to the request of the data subject, and data subjects shall also be informed of the existence of this right. This is it for this topic, and I want to hand over to my colleague Olivier, which will go into the details of the guidance for the lead authority provided by the working party.
Thank you, Giuseppe. Indeed, the third piece of guidance that's been released by Article 29 Working Party relates to the designation of the lead supervisory authority. As you know, the role of the lead supervisory authority pursuant to the GDPR is to ensure consistency in the implementation of the GDPR in situations that involve several member states. More precisely, the situation at stake is the situation of cross-border processing activities, so that involves several member states. The first situation of cross-border processing activity is the situation of establishments of a controller or processor in more than one member state. And there is also a situation of processing and a situation of a single establishment of a controller or processor in a single establishment in the Union. But if the processing substantially affects or is likely to substantially affect data subjects in more than one member state. And here the guidance gives us some further details on what is meant by substantially affect. And a processing that would substantially affect data subjects in more than one member state is a processing that would have a significant impact on the data subjects, and the Article 29 Working Party gives several criteria as to what would be considered as substantially affecting the data subject. And for that, several criteria such as the type of damage that could be caused to the data subject, the types of data processed, or the range of data, especially if it's a wide range of data, should be taken into consideration to determine if there is a substantial effect on data subjects in more than one member state. So that being recalled, how do you identify a lead authority when it's the case of a controller? First of all, and that's also true for processors, the main establishment of the controller has a key role to determine the lead supervisory authority. In the case the controller has several establishments in the EU, the first assumption will be that the main establishment should be the central administration of the business, unless another establishment in the EU decides on the purposes and means and has the power to implement the decisions relating to the data processing. So here the Article 29 Working Party lists several criteria that could be taken into consideration. So for instance, where are the decisions made about the purposes and means of the processing, and where such decisions receive the final sign-off? Also, where the decisions about the business activities that involve the processing are made, all these criteria and a few others listed by the Article 29 Working Party allowed to determine if another establishment should be considered for identification of the lead supervisory authority. Also, it should be noted that if several cross-border processing activities and decisions are made in different establishments, there will be several lead authorities. So there's not always one lead supervisory authority for a group of entities connected to several data processing in the same group of business. And also, the key items for identifying the lead supervisory authority when it comes to a processor are relatively similar as for a controller. The main establishment of the processor has a key role and will be the key factor for the identification of the lead supervisory authority. But if the central administration should be taken a close look first at an establishment where the main processing activities take place could also be then considered for determining the lead supervisory authority. So very quickly, we'll move now to local implementation and guidance for Belgium.
Thank you, Olivier. Belgium provides a good example for a good link with what we just discussed, because in Belgium, the Privacy Commission has adopted specific national recommendation to follow the three guidelines published by the Article 29 Working Party on DPO's lead authority and data portability. And was it necessary to have such an implementation guidelines? Certainly not. So you probably have to see that as a way to give more publicity to the Article 29 guidelines, and it raises interesting question on the legal value of the Article 29 guidelines. But at least that is one of the things that the Belgian Privacy Commission has done, is to put those specific recommendations asking controller to follow the guidelines of the published by the Article 29 Working Party. What the Belgian Privacy Commission has also done is to publish several guidance documents to help to ensure compliance with the GDPR. Essentially, there's a 13 steps plans which cover various issues. There are specific websites and page on the website of the Belgian Privacy Commission which kind of give guidance separately for controller, processor, and data subject, and there are also specific Q&As covering some issues of the GDPR. All that is a rehash somehow of the GDPR, gives some practical hints on how to implement that. I mean, what we can draw from that into the hints of the specificities of the Belgian market. I mean, one thing is that's interesting to note is that under the GDPR there will be no more an approval process by royal decree for BCI, binding corporate rules, which is one of the ways to transfer data outside the European Union. I mean, this is currently a very burdensome and difficult process, and that will go away with the GDPR. Also, an interesting topic that is raised is the right of appeal. Currently, there's no real right of appeal because there's no real sanctioning power of the Belgian Privacy Commission. As you know, this will change with the GDPR, and the question is really what will be the forum for that appeal. I personally think that it will probably be the Brussels Court of Appeal, which is really the appeal body for all regulators. But we have to see how that has not been set yet. Final point, and that stems more from the contribution of the Belgian Privacy Commission in the negotiation of and the adoption of the GDPR, is the fact that it's been in Belgium. It's always been very clear that Belgium is not a pro-DPO, compulsory DPO member states. Contrary, for example, to Germany. So the idea here is, besides those cases cited in in the GDPR where DPA are compulsory. Most likely in Belgium there will be no additional compulsory DPOs, and it will be up to the parties to decide and the controllers to decide whether they want to establish such DPOs. An interesting thing that's been published is the recommendation regarding data protection impact assessment. That is a document that has been put for consultation early this year, and the consultation closed at the end of February. It's very interesting because, of course, as you may know, the Article 29 Working Party is itself working on such guidelines on data protection impact assessment, and is set to adopt them and to publish them this year. So clearly, it's interesting to go and see the Belgian guidelines, because that will certainly influence the work of the Article 29 Working Party in that regard. The most interesting part is, of course, that the document contains a list of processing activities where you need to have to conduct an impact assessment, as well as a list of processing activities where you're exempted from such obligations. It's kind of a presumption that you don't need to do it for those kind of processing activities. I'm not going to go through all the list. There are 12 and 7 cases listed in the recommendation. That is worth having a look. Besides that, there are also some indication on what you need to do in terms of risk management, how you should set up your risk management approach, and that is kind of in line to some documents published by European agencies in the area. So that is a very interesting document that may influence also the European debate in that area. Then we look at, beside the Privacy Commission, there's also the Crossroad Banks for Social Security, which has launched a roadmap on how the GDPR will be implemented in Belgium in the sector, social security sector. There, I think the main point for businesses, and what's interesting is the kind of priority action. So there is, of course, it's difficult to prioritize what needs to be implemented first, and here there's clear guidelines that need to focus on DPO designation policy, having a registers of processing, privacy by design, and a register for all data breach that occurs. So those are kind of, in the sector, what you need to focus on. In terms of the next step, we are waiting for draft legislation, which normally should be adopted by the second half of this year, and that would probably draw more interesting information on how exactly the Privacy Commission is going to act on the basis of the GDPR. So that's a nutshell what happens in Belgium, and now it turns out to Olivier for how things happen in France.
Thank you, Laurent. So here, a quick update on what's happening on the French side in respect of the GDPR implementation and guidance from the CNIL. First of all, it should be noted that the CNIL has not issued a national guidance on the GDPR because the position of the CNIL, so far at least, is to fully endorse the guidance issued by the Article 29 Working Party. And actually, the CNIL contributes to the discussions at Article 29 Working Party level by organizing consultations and conveying the feedback to help on the drafting of the guidance of the Article 29 Working Party. So recent consultations have organized at the French level by the CNIL have included consultations on breach notification, obligations on the consent, and also on profiling. And that, the result of those consultations will serve as a basis for discussion at Article 29 Working Party for the future guidance to be issued by the Working Party. Also, the CNIL has, if it has not issued some guidance, it has provided some tools, including a 6-step implementation plan for the GDPR, And such plan includes the usual data mapping and ranking of priorities for compliance steps, which we actually discussed last time in the different implementation steps that could be very useful for designing your compliance effort to prepare the GDPR. But also in this 6-step implementation plan, the special focus by the CNIL is actually on the DPO, the data protection officer, so also on the data protection impact assessment, the prior impact assessment, and also on the documentation of obligations that will apply to the controllers and processors. First of all, because the position of the CNIL on the DPO is that it's a key enabler for compliance. So even though the designation of a DPO in France will probably not be always mandatory as in Germany, the recommendation of the CNIL is really to implement a DPO for all businesses whenever possible. Also on the privacy impact assessment, it is considered for the CNIL as a critical step, especially for high-risk data processing. And the CNIL, after releasing a very complete methodology on the PIAs, is also now working on a tool that will be made available for businesses to run and document their privacy impact assessment. So that will be very interesting to follow. And finally, it should be noted that the CNIL has made available a template of the records for the processing activities that will be compulsory for the data controllers and data processors. In addition to that information about the efforts from the CNIL, just a quick update now on the current status of the regulatory landscape for data protection in France. As some of you may know, in France, the regulatory framework for data protection has been updated recently in October 2016 by the law for a digital republic. And some of the latest changes have included increased information for data subjects, notably in relation to the retention period for the personal data. So that's a move forward in the direction of the GDPR. There is also a new broader right to portability that is not yet effective, but that could be broader than the right to portability that will be afforded by the GDPR. There is also now higher administrative fines up to 3 million euros, so it's not already the same threshold and very important fines as provided by the GDPR, but still we're getting closer to the fines provided by the GDPR. And there's also recently a class action that's been created, but that for the time being only aims at remedying breaches of the data protection framework and not to compensate losses. So finally, I'll say that further adjustments from the legal framework are expected, in particular for a clarification with respect to a right to data portability and the possible extension of the class action to cover compensation of the losses suffered. But that will be hopefully the subject of a law that should be drafted over the summer of 2017. And with that, I'll hand the floor to Undine for the report on Germany.
Thank you very much, Olivier. So other than in France, in Germany, we already have a draft law on the table to adjust the existing Federal Data Protection Act to GDPR requirements. And this draft law is actually already in the legislative process. So as some of you might know, Germany has a federal system, which means that certain subject matters, such as data protection, require not only the consent of the German Parliament, but also the consent of the Federal Council, comprising of representatives of the various German states. So there is currently a ping-pong game ongoing with regard to this highly debated draft law. However, commentators and experts expect that a decision about this draft law will still be taken during this legislative period, which means before this summer break. The general approach that this draft law takes with regard to adjustments to GDPR requirements is to be very comprehensive. It almost seems that the German legislator was trying to make use of every opening clause of the GDPR to ensure that the current German data protection law requirements continue to the extent possible under the GDPR. A good example of that is the requirement for appointment of DPOs. Here the draft law states that entities that usually employ at least 10 people with automated processing of personal data have to appoint a DPO. So this is similar to the currently applicable requirements for the mandatory appointment of DPOs here in Germany. The draft law also contains special provisions for data processing of special categories of personal data, such as health data, and for processing for purposes of the employment relationship. With regard to the latter, it might be interesting that these provisions detail the requirements for employee consent and also the requirements for monitoring employees to detect crimes. The draft law also contains provisions that actually restrict to a certain extent the rights of data subjects. And this is quite subject to a debate because some, in particular representatives of the DPAs, argue that this might be a violation of the GDPR. Finally, the draft law also contains provisions when criminal liability even will be triggered for certain data protection violations. Apart from this draft law, there is also guidance available, various guidance available from German data protection authorities on GDPR requirements. First, the Federal Data Protection Commissioner has actually issued a rather comprehensive explanation of GDPR requirements. Also, the state supervisory authorities, the so-called Düsseldorf Circle, or in German Düsseldorfer Kreis, has published a decision that existing consents remain valid under the GDPR with certain exceptions. The Bavarian Data Protection Agency has issued 18 papers or in a form of short commentaries on several aspects of the GDPR so far. And new papers are usually published every 14 days, and I can only encourage you to have a look at the website of the Bavarian DPA, because English translations of these short commentaries will soon be made available. Finally, the State Commissioner for Data Protection of North Rhine-Westphalia has published guidelines regarding the DPO under the GDPR. So this was a short report for Germany, and with that I turn it over to my colleague Giuseppe for Italy.
Many thanks, Undine. We'll go to see what's going to happen in Italy for the next few months with respect to national guidance. Well, allow me to say that the Italian DPA, the Garante, has adopted a lean approach, which is quite similar to the one of the French CNIL. In principle, the Italian DPA is already clarified in various interviews by its officers and members that it does not intend to issue national guidance. This is clearly for the purpose of preserving the harmonization effort of the General Data Protection Regulation. So this does not mean that they are not going to issue any kind of documents, but on the contrary, there will be a number of documents, and we are still waiting to see the first of them, which will promote strict adherence to the guidelines which have been issued and which will be issued by the Working Party. As far as we know, the Italian DPA will focus on the efforts expressly assigned to the domestic authorities and in the intentions of the Garante. This will be mainly for assisting small and medium enterprises which cannot afford the legal expenses and costs related to obtaining opinions. So apparently those companies should rely on the guidance issued by the DPA. In particular, we already know that the Garante will issue white and black lists relating to the need of a privacy impact assessment. This is something which is already been stated by Article 35 of the GDPR, and this is a task expressly assigned to domestic authorities. We will see what will be issued by the Garante in the next few months. At least this is something that should be issued by the end of this year. Moreover, the Garante also clarified that it will promote the issuance of ethic codes and certifications. Again, this is for the benefit mainly of small and medium companies, because by adopting the measures mentioned in such codes or obtaining certifications, it will be possible for those companies to give evidence that they are complying with the GDPR. This is the intentions of the Garante. Other implementing efforts will be for the benefit of public entities, which will be subject to the mandatory appointment of the data protection officer, the issuance of clarifications and training tools about the activity which will have to be carried out by the data protection officers. We do not know what type of training tools the Italian authority has in mind, but we will see. This is something that should be, again, issued in the next few months. Then there is something which has been debated in the last month, which is the validity of the Italian Data Protection Code. The Italian Data Protection Code actually was implementative of the 1995 directive and may potentially remain in force, especially on certain aspects which are governed by member states. So we will see which parts of the Italian Data Protection Code will remain in force. Another relevant question is about the validity of resolutions issued by the Data Protection Authority in light of the Data Protection Code. Apparently, these will remain in force to the extent they do not conflict with the newly implemented national European regulation. Another activity which will be carried out will be the revision of the structure of fines by the Italian authority, and last but not least, the issuance of a resolution which will summarize the outcome of the preliminary checkings carried out so far on the basis of Article 17 of the Italian Data Protection Code. We will expect all these activities at least before the General Data Protection Regulation will be binding in May 2018. This is it for the Italian efforts, and I now hand over to my colleague Paloma for an update on Spain.
Thank you very much, Giuseppe. As in other European countries, in Spain, the GDPR has generated an intensive activity by the competent authorities. On one hand, the government has started the procedure to amend the Spanish data protection law. It has created a specific commission to manage this modification, and in February opened a public consultation. In the next weeks, we expect to have a draft of the new Spanish data protection law, and the government will open a new public period of audience before summer. The plan of the government is to have a new data protection law in September. But today, the core activity of the GDPR has been carried out by the Spanish Data Protection Agency. This authority has published 3 main documents of the GDPR. The first document is a general guide in which the authority provides to the data controller practical steps to adapt their activity to the new obligation during the transactional period until May of the next year. The key recipients of this document are medium and small company, and it includes a list of items that data controller must verify during this year to comply with the GDPR. The second document is the guide of the information obligation. This guide is addressed to data controller, data processor, and data protection officer. The first key point of this guide is the confirmation of the obligation of the data controllers to review and adapt before the month of May of the next year all the procedures, forms, and documents used by the company to include the new requirements of information established in the GDPR. The second key point of this guide is the recommendation on how to comply with the information obligation. The Spanish DPA proposed to use a multi-level information model which consists in provide to the data subject the information required by the GDPR in 2 phases or in 2 levels. At first level, provide basic information. This basic information must include the identification of the data controller, a brief description of the purpose of the processing, the legal base used for the processing, the recipient of the data, and a reference of the data subject rights. And in the second level, provide to the data subject the rest of the information required by the GDPR. The guide includes a practical example applicable for several scenarios. The last document published by the Spanish DPA is a general guide with guidelines to build an adequate data controller-data protection relationship under the GDPR. In line with the provision of the GDPR, this document identifies 5 key points to take in mind when we are going to formalize a relationship with a data processor. The first guideline is regarding the scope of the processing. The rule is that there is no limitation about the type of processing that the data processor can carry out on behalf of the data controller. The second guideline is that the capacity of decision of the data processor must be always limited to adopt the functional measure to provide the services. The third guideline is that in all cases, the data controller will have the responsibility to choose the adequate data processor. The fourth guideline is that when the data processor is located in a third country, it will be necessary to comply also with the international data transfer rules. And finally, the DPI confirms that it's not mandatory to inform the data subject of the existing data processor. The highlight of this guideline is that it includes a model of data processing agreement as a reference to use by the data controller. In addition to these main documents, the Spanish authority has developed other minor GDPR activity. For example, it has published a brief document with questions and answers about the GDPR, or other document, a brief document about practical implication of the GDPR. In the following months, this type of activity will continue, of course, and we expect in the next annual session of the Spanish DPA that to have a specific chapter of the GDPR, and in terms of new guide or guidelines, we expect to have two new guidelines, one related to the data security breach, another of protection of impact assessment. In general, these are the main implementation efforts carried out in Spain. And now I will give way to my colleague, Liz, who is going to cover the United Kingdom implementation efforts.
Thank you, Paloma. Last but not least, we come to the United Kingdom. The UK Information Commissioner, who enforces the current Data Protection Act and will enforce the GDPR, has so far issued 3 pieces on the GDPR. These include 1, a 12-step preparation guide to the GDPR, 2 times as many steps as the CNIL and 1 step less than Belgium. 2, an updated guide on data protection notices, which signposts the GDPR requirements. And 3, draft guidance on consent under the GDPR. The public consultation on this document just ended last Friday. The draft document on consent is the most significant document. Here are the key themes that go through it. First, consent should not be used if it seems that it is difficult to obtain, particularly when a better basis of processing is available. There must be an aspect of real choice and control by the data subject over data use for consent to be appropriate. 2, consent cannot be buried in long terms and condition documents. In the UK, this has been a particular feature in financial services documents. Data protection consents must be unbundled from the terms and conditions, and multiple sub-consents should not be included in a single broad consent. 3, no pre-ticked or opt-out boxes, that is, boxes you tick if you do not want to receive further information. At the consent stage, this is a particular bugbear of the Information Commissioner, and she states categorically that there is no such thing as opt-out consent. This is not to be confused with opt-outs that are appropriate when consent has already expressly been given. 4th, the Information Commissioner also advises that data controllers will need to keep their consents under review so that they stay current with evolving privacy practices. And she reminds us that consent can be withdrawn by the data subject. In issuing her guidance on consent, the Information Commissioner expressly states that she is looking toward Europe in her approach, and this may be a signpost on how the UK government is approaching Brexit in this area. We will learn more in the months to come. The Information Commissioner has said that it is inappropriate to use consent if there is an imbalance in the relationship, because this means that the consent is not freely given. She has said that legitimate interests, or in the case of public authorities, public task, should be used as a basis instead. She focused these comments on public authorities, employers, healthcare providers, and those seeking consents from children. I want to draw out just one of these in more detail to give an indication of the Commissioner's approach as it flags a change to current practice. In the employment context, my European colleagues have been cautious about consent as a basis of processing, arguing that the inequality of bargaining power between employer and employee means that consent cannot be freely given. UK practitioners who work with employment contracts note that there are many instances where an employee, rather than the employer, may have considerable bargaining power. And practitioners have argued that the give and take in that relationship means that the data protection consent is in fact freely given. The European position prevails in the draft guidance. In the employment context, which includes not only terms and conditions of employment, but also workplace monitoring of IT use, the Information Commissioner suggests that legitimate interest is a far better basis of processing, provided that the notice requirements of the GDPR, and in particular the transparency requirements, are met. This harks back to our consideration of consent in our first webinar. This means that employers may have considerable work in preparing and circulating full notices to employees, in the months to come. Part of this debate also contrasts the use of consent language as a means of recording an agreement and consent language as a means of providing information. The latter, consent, providing information, really goes in the guidance of the Information Commissioner to the transparency requirements of giving a data protection notice. As indicated in the slides, it is likely that most comments in the guidance will be in these specific areas. The other interesting aspect of the guidance goes to record-keeping requirements, another area covered in our previous webinar. The Information Commissioner is looking for the actual underlying notice consent documents to be kept, and not just details of the date and the type of consent that was given. This may be a particular challenge to e-commerce providers. And again, as I mentioned earlier, no pre-tick boxes or opt-out boxes. And to grab attention, the Information Commissioner reminds us of the potential consequences of getting consent wrong, being the highest of the administrative fines. That's all for the UK.
Thank you all for the excellent presentation. We'd now like to open the webinar to questions that have been submitted throughout the presentation. To ask a question, please go to the chat window located in the lower left corner of your screen. Type your question in the text box and click the Send button. We will pause for just a moment while we assemble any questions.
All right, so the first questions are coming in, and we have a question on the DPO. So that will probably be for you. The question would be, does the GDPR also allow for the external appointment of a DPO? And what would be the pros and cons?
Well, thanks for that question. It's a very important question, and we get this all the time from clients. The short answer is yes, the GDPR does allow for an appointment of an external data protection officer. In practice, this is done by engaging a consultant service provider and having an appropriate agreement in place, and then that person can take over that position. Now, in terms of pros and cons, obviously there are advantages and disadvantages for both an internal and external DPO. When we look at an external person, obviously that person will come in and have to bring a lot of knowledge at the beginning and bring in expertise at the same time, probably may be less up to speed yet with the company, organization, the culture, how things are done, the different projects, so there needs to be a learning curve for that person. At the same time, an internal DPO obviously knows the organization, the company, has short ways in terms of getting information and can help management supervise compliance. So I think this is probably a case where we would say it depends a bit on the type of organization. It depends on how they would like to run things, and so there are pros and cons on both sides that we would be happy to discuss in more detail with you if that concerns you and one of your projects.
Thanks, Jörg. Actually, there would be another question for you because it's still about the DPO. So the question is, does the DPO have to be located in the same entity, which is the EU headquarters, or could it be located somewhere else?
Another interesting, tricky question. The GDPR is very silent on the location of the data protection officer. So in theory, yes, that person could be located in another entity. What is most important from the GDPR's perspective is that that person is formally appointed for that position, and it can also be the person can be appointed for a number of different entities. So you can have one DPO for a group of companies across the EU, and then where that person is physically located is not relevant as long as that person is appointed formally and also has the ability to support, manage, and to be available for not only for requests from the organization, but as well as individuals such as employees, customers, vendors that may reach out to him or her.
Thank you, Jörg. We now have a question about data portability. So, Giuseppe, maybe you can address that. The question would be, what is the expected data format for providing data to subjects that have requested portability, and whether there are any technical standards already fixed?
Yeah, thanks, Olivier. I have to say that there is no clear indication so far of a single specific format provided by Article 20 of the GDPR. Anyway, we know as of today that the data must be provided in a structured format, a format which can be and is commonly used by computer and is machine readable. So at least these are the minimal requirements that should be included in the data provided to data subjects in order to facilitate interoperability. Then I may add on my side that no expensive licensing must be implied by the use of the format. So at least this is what we know for the time being.
Thank you very much, Giuseppe. So we're conscious of the time. I think the hour for this webinar is now over. So we would like to thank all attendees, and obviously we'll respond to the other questions that we received. We'll respond separately to the different questions. So thank you so much for attending.
Thank you again to our presenters from Jones Day, and a special thanks to everyone in the audience. If you meet all of the criteria to receive CLE credit, you will receive an email within 24 hours. If you do not receive the email, please contact Beacon Live. This concludes today's programming.